It may come as a surprise to most people that federal sentencing always comes from the judge. In other words, a jury is not allowed to impose a sentence in a federal case. In determining a federal sentence, a judge will consider a number of factors. First, the judge will start with the pre-sentence report. The pre-sentence report includes biographical information about the defendant, their upbringing, their criminal conduct, their criminal history, as well as any mitigating information that was put forth. The judge will also consider the United States sentencing guidelines. These guidelines are advisory, they're not mandatory, but they are a starting point for a judge in any criminal case. Finally, the judge will consider the filings by both parties. This includes the prosecution as well as the defense. Common examples of defense filings are sentencing memorandums, motions for downward variance, or objections to the pre-sentence report. After considering all the information that was put before the court, the judge will determine a sentence. In the federal system, these sentences are often much harsher than they are in the state system. In a federal case, when you're negotiating a plea with the prosecutor, you're really negotiating perhaps what sentencing range you're going to be subject to. You're not negotiating what your actual sentence will be. In the state system, you might negotiate for probation or a certain number of years that you're going to serve. In the federal system, that type of a plea agreement is almost unheard of. And that's because the judge, and only the judge, has the power to sentence a person in the federal system.